Good evening, everyone. On behalf of Brick Court Chambers, it's my very great pleasure to welcome you all to this evening's lecture, the third annual Jonathan Hirst QC Commercial Law Lecture. We established this lecture series 3 years ago upon Jonathan's retirement from the bar to mark the immense contribution that he had made to the profession and also particularly to Brick Court Chambers, where Jonathan had practiced throughout his career and where he had been one of our joint heads of chambers for 11 years from 2005 to 2016. Very sadly, Jonathan was no longer with us by the time of the second annual lecture last year. He remains much missed, but we're delighted tonight to again be joined by his sister, Rachel. It is in many senses fitting that tonight's lecture is being given by Jonathan's immediate predecessor as head of chambers, Sir Christopher Clarke. Sir Christopher also practiced throughout his professional career at Brick Court and became its sole head of chambers in 1990. That was a role which he performed exceptionally for 14 years, when sadly for us at least, although not the development of the law, he took up appointment to the Commercial Court. In 2013, he was appointed as a Lord Justice of Appeal, where he sat until his retirement in 2017. To our delight, he then returned to Brick Court Chambers as a door tenant and now sits as an arbitrator as well as the president of the new Bermuda Court of Appeal. Sir Christopher's highly topical chosen subject tonight is London, the venue of choice for international disputes in the years ahead. I'm sure we're all particularly keen to hear what he has to say on that subject. So without further ado, I will hand over to Christopher.
It's a great honour to be asked to deliver the third Jonathan Hirst Memorial Lecture. I did not, however, realise when I accepted the invitation that at the time when it came to be delivered, the executive of our nation would, how shall I put it, be bordering on the dysfunctional, and our legislature consumed by a single topic in relation to which every option appeared unacceptable to a majority of our elected representatives. Much less did I realise that I would be delivering it 3 days before elections to a parliament from which 3 years ago we were supposed to be departing. In those circumstances, it seemed to me that it would be desirable to look on the bright side at a functioning part of our affairs, namely that part of it which is devoted to the resolution of business disputes. We tend to think that our system for the resolution of business disputes is the best, and it is. I want, however, to spend some time analysing why that is so. The first great benefit of our system is English law itself, to which subject I shall in a moment revert. The second is that we have an independent, impartial, and fair-minded judiciary. The combination is such that our system has a justifiably strong worldwide reputation, as a result of which it enjoys a dominant position in the international legal services and dispute resolution market. That our judges are independent and impartial may be thought to be no great insight. We are, however, in this, as in many other respects, the envy of less happy lands. In some jurisdictions there is corruption or partiality of one kind or another. Sometimes it is political in the sense that in matters which are deemed important to the state or the ruling party or powerful persons, arrangements are made to ensure that the, quote, right, close quotes, decision is made. Or in some countries, the judiciary is reluctant to decide a case adversely to the government or to powerful interests, either out of concern for their own position or a general timidity. Sometimes corruption is purely monetary, and one should not suppose that this is solely a non-European problem. A survey a few years ago of some 11,712 judges in 18 EU countries revealed that more than 10% of them thought that some of their number were taking bribes, or were not sure whether they were. In some countries, over 50% of the judges thought that. Next, our judges who determine international business disputes are highly competent. This is because their members, particularly in the Commercial Court, the Chancery Division, and the Technology and Construction Court, have usually been highly successful practitioners with experience in the application of law in practically every business field. You would expect someone like me to say that, but that does not stop it being true. In 2014, the Ministry of Justice published a report from the British Institute of International and Comparative Law on the factors that influenced international litigants' decisions to bring commercial claims to London-based courts. One of the key findings of the research was that the first and foremost reason why London was considered to be a popular and natural jurisdiction for high-value cross-border disputes was the reputation and experience of English judges alongside English law. That reputation, of course, derives from their manner of trying cases and from the quality of their judgments, where you will usually, there are exceptions to this as to every rule, get a clear, reasoned and well-expressed decision on the facts and the application of the law thereto. Allied to the quality of the judiciary is the quality, size and availability of the legal profession in both of its branches. London and other cities have a copious supply of practitioners of outstanding ability, both in independent practice and in-house, who have experience in dealing with the realities of international commerce and finance, sometimes in somewhat arcane fields. Several of them are in this room, as you see. It is no surprise that London has many of the world's leading firms and advocates, and that more than 200 overseas law firms from some 40 jurisdictions, employing over 10,000 people, practice in the United Kingdom. The United Kingdom is the largest legal service market in Europe, and second only to the United States globally. The next factor in favour of dispute resolution in London is our court system, by which I mean both the range of courts available and their physical infrastructure. As to the latter, the Rolls Building is the largest specialist centre for the resolution of financial, business and property litigation anywhere in the world, brought into being with the support and enthusiasm, but not without some difficulty, of the City of London. As to the former, there is a court for every business need. The Commercial Court has for over 120 years been the world's leading forum for the resolution of trade, shipping and insurance disputes, and is now up to its full complement of judges after a number of years at very much below full strength. The Chancery Division has unrivaled experience in corporate and financial disputes. The Technology and Construction Court some time ago regained its rightful place as a leading court for the determination of construction and engineering disputes, with an admirable procedure for speedy dispute resolution by adjudication. The latest data from the Commercial Court indicates that in the year 2007-8, international cases accounted for some 70% of the business of the court, a truly international court. Statistics for the year down to March 2019 indicate that litigants came from 78 different countries and that there was a 63% increase in the number of cases heard over the previous year. The vast majority of cases brought before the court are claims for sums well in excess of £10 million. The largest was for $3 billion, with more than a dozen for over £100 million. Many arbitrations, of course, concern awards for very large, sometimes billions of pounds or dollars. One has to recognise that there are potential downsides to London litigation. The cost of lawyers can be high, and there is a permanent risk of over-egging the pudding. When one sees 8-figure cost bills on each side, admittedly in billion-dollar litigation, one begins to wonder a bit, although to change metaphors, one can see that in that context, no stone should be left unturned. And I note from a recent article in the Times that eye-watering fees may actually attract some international clients, particularly the Chinese, since an ability to pay them is an exhibition of net worth. Another reason for choosing London is that our system involves A, disclosure of documents, B, oral cross-examination, C, oral advocacy, D, the loser usually pays costs, and E, the absence of an automatic right of appeal. I realize that something can be said against each of these, or aspects of each of these, but in essence the combination is a good one. And for a respectable claim, there is a realistic chance of obtaining funding on a conditional fee basis. Although the ability of litigation funders to rely on the Arkin cap to limit their liability in respect of adverse costs to the amount of funding they contributed is no longer assured in the light of the decision this year in Davey against Money and others. Another reason for the selection of London is the steps taken to increase efficiency in the determination of disputes. I have in mind things such as, firstly, the current emphasis in the commercial court on case management, which may be that which contributes to the 60% settlement rate in commercial court cases. Secondly, the shorter and flexible trial procedure in the business and property courts. Thirdly, the new disclosure protocol in the commercial court and in most other courts within the business and property courts umbrella, which aims to retain disclosure but ensure that it is proportional to the issues in the case and introduces a scheme of initial disclosure, followed, if appropriate, by extended disclosure, which may take different forms. Next, there is the working party in the commercial court on witness statements, which aims to address whether our practice in relation to written witness statements remains appropriate. Then there is the introduction of the financial list in the business and property courts, that being a special court to hear cases requiring particular expertise in the financial markets, or which raise issues of general importance to those markets, or where the value at issue exceeds £50 million. That's enough, of course. An equally important reason why London is and should continue to be a venue of choice for dispute resolution is its suitability as a place for arbitration. I do not propose to embark upon a comparison of the relative advantages as between curial and arbitral determination, not least because it would be possible to spend every week somewhere in the habitable globe attending a conference on the advantages of arbitration, which are very considerable but not necessarily overwhelming. It is sufficient to draw attention to the range of arbitral facilities in London under the auspices of well-known arbitral institutions such as the LCIA, the LMAA, GAFTA and others, and arbitrations on an ad hoc basis. If you want an arbitrator of practically any kind, you can readily find one here. It's impossible to tell how many awards are issued every year, but it may well be over 1,000. In this connection, it's relevant to observe that the commercial court has what has been described as a symbiotic relationship with arbitration. Roughly 25% of the claims issued in the commercial court, relate to arbitration, covering challenges to awards on jurisdiction or on points of law or on irregularity grounds, together with the grant of injunctions in relation to arbitrations, particularly anti-suit injunctions, and the enforcement of awards, both of which are critical in the support of the court for arbitration. In this connection, it is noticeable how successful arbitrators in England have been so far as claims of irregularity under Section 68 of the Arbitration Act are concerned. This is not perhaps wholly surprising, since the section was designed so as only to be available in extreme cases. A set of figures mentioned in the minutes of the Commercial Court Users Group in March of 2018 records that in the Commercial Court in 2015 only 1 out of 34 challenges succeeded, in 2016 none out of 31, in 2017 none out of 48. In 2018 there have, however, been at least 3. And the number of appeals overall, whether under Section 68 or Section 69, is a minuscule proportion of the total number of awards. There has, of course, been a continuing debate as to whether or not the right balance has been struck between avoiding unwelcome interference from the courts in arbitral decisions and providing access to a court which, unlike an arbitral tribunal, is a source of law, so that it can deal with errors or simply questions of law, as well as irregularities in arbitral proceedings. In favour of a wide approach is that it would or could mean that commercial law had a better chance to develop and be widely known, which is lost if decisions involving important or interesting questions of law are determined, not necessarily always in the same way, by awards which, save for the occasional samizdat circulation, are not available for public consumption. I belong to those who think that we have got the balance about right by confining leave to appeal under Section 69 of the Arbitration Act, unless the parties have agreed to exclude it, to cases where the question is one of general public importance and the decision of the tribunal is at least open to serious doubt, and to cases where the decision of the tribunal on the relevant question is obviously wrong. That observation is subject to two qualifications. In relation to the first criterion, it seems to me desirable that there should be a certain amount of elasticity in determining what is of general public importance. That test ought to be satisfied if the importance is for a particular trade or section of a trade or business, or to persons who find themselves in a particular but likely to be repeated circumstances. As to the second criterion, obviously wrong, I wonder whether it is quite right to say that this criterion means that the tribunal's reasoning must reveal, quote, a major intellectual aberration, close quotes, to use the expression of Lady Justice Arden in a case called HMV UK Propinvest Friar Limited Partnership, that phrase being derived from a first instance case called Brace of Dune Wind Farm against Alfred McAlpine Business Services, in which Mr. Justice Aikenhead was not, in my opinion, using that phraseology as some form of synonym for obviously wrong. I must confess an interest in making this point. I am aware that there is currently an application for leave to appeal against an award in which three of us decided in a particular way. As is usual in this case, though the successful party says that the tribunal was as brilliant as they come, and the award a masterpiece of the draftsman's art, the unsuccessful party says nothing about the supposed quality of the tribunal and says that the decision was obviously wrong. I'm largely indifferent as to what view, if any, the court itself takes, but I would, I think, feel slightly distressed if the basis upon which our leave were given to appeal against our award was that we had been guilty of a major intellectual aberration. There are many other good reasons for choosing London. For many business litigants, it is a neutral forum. It may be particularly suitable if the litigants are from countries lacking strong rule of law principles, with an ill-developed law, a weak or unreliable judiciary, or unreliable lawyers. Because of London's position, the subject matter of many disputes, or the assets hoped to be realised therefrom, will be London-based. Another reason for choosing London is the availability of high-class mediators. The range of mediation bodies and mediators and their different competencies is considerable and their success record remarkable. These skills are, of course, needed because ADR has now become a feature of dispute resolution in London and is often in practice required, or at any rate highly encouraged, by the courts. As I have said, London is a prime place for the determination of business disputes because of English law itself, which has become the most commonly used law in international business and dispute resolution. But one needs, I think, to go beyond simply asserting that as a sort of USP and analyse why English law is good for business. As to that, firstly, it is of high quality. It is well developed, extends over a broad range, and is within limits flexible in application. Why is that so? The answer seems to me to be twofold. Firstly, history, and secondly, process. England has been a trading nation for generations and has built up its law on the back of that trade. That was helped by the establishment at the end of the 19th century of the Commercial Court and the distinguished judges who sat in it over the decades, some of whose names have become bywords for legal analysis. The classic subject matter of the typical commercial court dispute, shipping, banking, insurance, reinsurance, business contracts, and the like, has established a whole corpus of law and led to English law being the law of multitudinous contracts. And we have the immense benefit of a system of equity. It is sometimes difficult to explain to those unfamiliar with it the operation of the fused systems of law and equity, with the latter originating in an appeal to the conscience of the sovereign, of which the Chancellor was the keeper. But the development of equitable principles to mitigate the rigours of the law has, I think, fashioned our law well, as has in more recent years the impact of administrative law concepts, which has in some cases, the exact scope of which is debatable, served to circumscribe the operation of contractual discretions so as to preclude them being exercised in an arbitrary, capricious, or irrational manner. By process, I refer to the fact that the common law is not a code. It is in effect a series of principles, propositions, and rules whose content, scope, and limitations have been worked out by their application by practitioners and judges to specific cases, the law being discerned from those cases interpreted together and, where necessary, reconciled or developed. This has proved to be a highly valuable, practice-based method of legal reasoning, which enables the common law to seek to achieve practical justice by applying and, if necessary, adapting basic principles to novel situations. A law that stands still is likely to ossify and cease to be fit for purpose. Secondly, English law is relatively certain. We have resolved quite a lot of issues over the years, although it never ceases to surprise me that there always seems to be some question which must have arisen hundreds of times, which remains unanswered, at any rate at the highest level. Part of the reason why the English law is so suitable for business disputes is precisely because of its content. The parties are free to contract as they wish. Subject to any applicable statutory constraints, the function of the court is then to give effect to the commercial bargain made, whatever it may have been. The law adopts what is now a pretty well-established and broadly satisfactory approach to the construction of contracts. Leaving aside any question of rectification, itself a rare remedy, the words of the contract will be interpreted objectively by asking what a reasonable person in the position of the parties, possessed of all the reasonably available background information, would understand the words to mean, whatever one or more of the parties may have subjectively intended. If there are two possible constructions, the court is entitled to prefer the one more consistent with business common sense. If the meaning of the words is clear enough, the parties will be held to it, even if the result is harsh. In essence, putting it in business terms, what you write down is, broadly speaking, what you get. Frustration apart, there is in general no escape for a contracting party, because fulfilment of its obligations becomes excessively onerous on account of an unforeseeable change of circumstances, such as was recently introduced by Article 1195 of the new French Civil Code. Exclusion clauses need to be clear and construed in a manner that is not repugnant to the whole purpose of the contract, but if they are clear, they will, subject to any statutory exceptions, take effect. Terms will be implied into the contract, but only leaving aside implications of law if it's necessary to do so, or the term in question is sufficiently obvious that it goes without saying. The parties can get relief for mistake if it was a common and fundamental mistake in relation to a critical matter, or if one party is aware that the other is under a mistake and seeks unconscionably to take advantage of it, but not otherwise. The contract can be terminated for breach of a condition or a fundamental or repudiatory breach but otherwise the remedy is in damages, which are, with rare exceptions, compensatory and not punitive. A contract can be frustrated, but this is rarely held to be the case. The United Kingdom leaving the European Union will, as the law currently stands, not do as a frustrating event, however frustrating it may be psychologically, in the light of the decision in Canary Wharf against the European Medicines Agency, although that case is, as I understand it, under appeal. Unlike in some civil law countries, there is no means of changing the extent or nature of the obligation if economic circumstances change. These points are an indication as to the sort of ways in which English law is good for business. We have, of course, always to remember the benefits of not having some of the things that we might have but do not. I have from time to time had the pleasure of judging a student's moot in Vienna, in which the imaginary contract which gives rise to the moot problem is governed under a system of law which seemed to make anything admissible for the purposes of construction. By the time we had taken into account, firstly, the negotiations, secondly, the parties' intentions, thirdly, the contractual context, fourthly, the terms themselves, fifth, the events after the contract, and sixth, what each party might be supposed to have known about the intentions of the other, the answer to the question of construction seemed increasingly impossible to give. I know that in English law interpretation is an iterative process, but under other systems the journey appears to me endless. I have mentioned a number of the advantages of English law and jurisdiction. One that I have not mentioned so far is, of course, the availability of intellectual titans at the highest levels, whose views are not always coterminous, and give the rest of us the opportunity to puzzle out how to deal with that circumstance. For those of you who are interested in the intellectual equivalent of a heavyweight wrestling match, may I commend a comparison of an article by Lord Hoffman, who I am delighted to see here, in the Law Quarterly Review in 2018, under the heading Language and Lawyers, with a lecture given by Lord Sumption in May 2017, under the heading A Question of Tastes, the Supreme Court and the Interpretation of Contracts. I feel justified in doing so, not simply on account of the great interest of these rival considerations, but also because both of them are or have been members of these chambers in one form or another. These impressive documents must be read for themselves, since the briefest summary I am about to give cannot do justice to either. In his speech, Lord Sumption describes how, to use his words, the House of Lords embarked on an ambitious attempt to free the construction of contracts from the shackles of language, using the concepts of, quote, the surrounding circumstances, close quotes, and, quote, commercial common sense, close quotes, and to replace them with some broader notion of intention. These attempts he ascribes in large measure to the towering figure, those are his words, of Lord Hoffman. He refers to Lord Diplock's ever-to-be quoted words in the Apuleius about avoiding interpretations that lead to unreasonable results. In essence, he commends a reassertion of the primacy of language, as opposed to using surrounding circumstances to, in effect, override the language, when the language used is the only way, he says, in which the intention of the parties can, under our system of interpretation, which excludes evidence of prior negotiation and subjective intention, be conveyed. Lord Sumption identified what he described as the retreat from that position and a return to the primacy of language as beginning in the Supreme Court with Arnold and Britain, in which Lord Neuberger said that the reliance placed on commercial common sense and surrounding circumstances should not be invoked to undervalue the importance of the language of the provision which is to be construed. Although, as Lord Sumption puts it, that retreat was, in his view, in rather muffled tones. In Lord Hoffman's article, he explains why, in his view, the old rules of construction were incoherent and wrong. He begins with an analysis of the way in which language is used to convey meaning, and how a distinction is to be drawn between the meaning of words, which he characterizes as word meaning, and what a speaker or writer means his word to mean, which he characterizes as speaker meaning, the latter potentially depending on the background and context in which the speaker speaks. He gives examples of where people speak elliptically, but their meaning is clear. The process of legal interpretation is, he says, a matter of speaker meaning. For this reason, a court can give effect to the meaning which the document would objectively convey to a reasonable person to whom it was addressed, notwithstanding, and herein perhaps lies the rub, that it contains a verbal error. This circumstance would be rare, and the interpretation to be derived from a conventional meaning would have to be irrational for that to happen. In his essay, he describes Lord Sumption as Wigram redivivus, Wigram being the author of a book which will I know have been your bedside reading for many years, namely the examination of the rules of law respecting the admission of evidence in aid of the interpretation of wills, published in 1831, which laid down a particularly strict approach to the construction of wills. It is not for me, a mere mortal, to mediate between these two deities. I suspect that the resolution is to be found in the proposition that a departure from the literal or word meaning of the words is only acceptable if that meaning produces a result so irrational or self-contradictory that the parties cannot have intended, and that it was plain to a reasonably objective person what the parties meant, and not simply that it is clear what a reasonable person would have agreed. That itself would appear to me to be a businesslike approach. I have so far referred to a number of nutshell points, which are, of course, the subject of realms of textbook and case law, as indicia of the suitability of English law for business purposes. It appears to me, however, worthwhile to consider a few cases which, to my mind, demonstrate with greater specificity how the approach of the English courts at the highest or second highest level have produced results which could be said to be business-friendly. In the case whose full name is Transfield Shipping against Mercantor Shipping, the court was concerned with a bulk carrier called the Apuleius. The charterers were bound to redeliver the vessel on the 2nd of May 2004. In fact, they delivered her on the 11th of May, because late in the day they had subchartered her out, and she was delayed at her second discharge port. Meanwhile, the owners had fixed the vessel to a new charterer for a 4 to 6 months hire, following on from the charter which was due to come to an end on the 2nd of May. The latest date for delivery under the new charter was the 8th of May. Since the vessel was not going to be redelivered to the owners in time for her to be delivered by 8th of May, the owners had to agree with the new charterers a postponement of that cancellation date. Thus it came about that in return for an extension of the cancelling date under the new charter from the 8th until the 11th of May, the owners agreed to reduce the rate of hire for the new fixture by $8,000 per day. As you can perhaps perceive, there had been a substantial and unexpected fall in the market over a pretty short period. The question was whether the owners were entitled to recover from the original charterers $8,000 per day for the whole period of the new charter, or only the difference between the market rate and the charter rate for the 9 days from May the 2nd to May the 11th. The House of Lords, reversing the decision of the majority arbitrators, the Commercial Court and the Court of Appeal, held that the owners were only entitled to the 9 days' damages. This was on the basis, so far at any rate as some members of the House were concerned, that although normally recoverability was dependent on whether the loss in question was a not unlikely result of the breach, this was only a prima facie assumption about what the parties may be taken to have intended, no doubt applicable in the majority of cases, but capable of rebuttal in a case in which, to use Lord Hoffman's words, the contract, surrounding circumstances, or general understanding in the relevant market shows that a party would not reasonably have been regarded as assuming responsibility for such loss. The decision has attracted some degree of containment. A number of later cases in England suggest that its practical application is likely to be exceptional, and the Singapore Court of Appeal, in a case called MFF Restaurants against Fish & Co. Restaurants, has declined to follow it. At the same time, the Hong Kong Court of Final Appeal has unhesitatingly adopted the assumption of responsibility test in a case called De Monza Investments against Richley Bright International. My purpose in citing it is that it seems to be an example of a development of the law which could be characterized as business-friendly, insofar as it treated as a criterion for determining the limits of loss for which the parties, as a criterion for determining limits of loss, that loss for which the parties in the relevant market should be taken to have assumed responsibility. I recognize, of course, that what you might describe as business-friendly may well depend on which side of the business you are on. My next example is the penalty shootout. In 2015, in Cavendish Square holding against Talal El Makdessi, our Supreme Court, sitting as a court of 7, revisited the law on penalties, which was described by Lords Newburgh and Sumption as, quote, an ancient, haphazardly constructed edifice which is not weathered well and, in the opinion of some, should simply be demolished. In that case, Mr. Makdessi agreed to sell to Cavendish a controlling stake in the holding company of the largest advertising and marketing communications group in the Middle East. The contract provided that if he was in breach of certain restrictive covenants against competing activities, he would not be entitled to receive the final two installments of the price to be paid, and could be required to sell his remaining shares to the buyer at a price excluding the value of the goodwill of the business. Mr. Makdessi subsequently breached these covenants, although not particularly seriously. In essence, the Supreme Court declined either to abolish or to extend the law of penalties, which has so often been described as a naked interference with freedom of contract, but it undoubtedly severely curtailed its application. The court, whose reasoning was not identical as between the members, said that the essential question was whether the clause was penal, but that it was not helpful to ask, as appears to have been done, appeared to have been the law for a century or so, whether it was a deterrent, or to put it in the decent obscurity of a Latin language, in terrorem. The true test, according to at least 3 members of the court, was whether the impugned provision was a secondary obligation which imposed a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. Those members of the court recognized that there could be a conditional primary obligation whereby the consideration for a sale could be reduced on account of the non-fulfillment of an obligation on the part of the seller, i.e. a breach, without thereby engaging the doctrine of penalties at all. This case, too, seems to me a good example of the way in which the court has moved towards a result which promotes a solution acceptable to business. Although, again, I doubt that Mr. Makdessi thought that was so, since he lost tens of millions of dollars, and the primary obligation of which he was in breach was pretty insignificant by comparison. I turn then to lies. Before 2016, it appeared to be the case that you would forfeit your claim against your insurers, not only if you dishonestly claimed more than your claim was worth, in which case you would recover nothing at all, but also if you made some false statement as to the circumstances of the accident, which was referred to as collateral lies, knowing that it was untrue or reckless as to its truth or falsity. Even if it turned out at trial, the claim was entirely valid. In Versluit dredging against Girling Industry, the Supreme Court, by a 4-1 majority, with the powerful dissent of Lord Mance, reversing the decision of the Court of Appeal and the Commercial Court, and notwithstanding earlier authority, including in the Privy Council, held that the forfeiture rule did not apply to justified claims supported by collateral lies. A policy of deterrence did not, it held, justify the application of the penalty rule in these circumstances. That was a step too far, a legal sledgehammer to a nut. This itself is an example of a businesslike approach, although, not surprisingly, the insurance industry did not see it that way. There are many other examples of cases where the courts have developed a sort of justice fit for business approach. One of those is the recognition that parties are free to agree that a certain state of affairs shall form the basis of a given transaction, whether that state of affairs be the case or not, sometimes perhaps inaccurately described as the doctrine of contractual estoppel. A second is the recognition of the validity, subject to the possible application of an estoppel, of entire agreement clauses, which are designed to preclude attempts to get round the unwelcome wording of a contract by reference to some supposed statement made in the course of negotiations of the contract in which the clause is obtained. A third example of a business-like approach is the rejection by the courts of some universal or general duty of good faith in the performance of contracts, save in the well-established circumstances such as insurance and partnership, coupled with a guarded but developmental approach to implying a duty of good faith or some similar duty in particular cases. See the seminal judgment of Mr. Justice Leggett, as he then was, in Yam Seng, Pte. Limited, in respect of relational contracts, which has been considered by the Court of Appeal in 3 subsequent cases. Many civil law systems, such as France, Germany, and Switzerland, import some form of general requirement of good faith in the making and performance contracts, as do those states in the United States of America which adopt the Uniform Commercial Code. Good faith is, one may think, a somewhat elastic concept, the requirements of which are opaque and never fully defined. There are, however, dangers for business in this context, since, as Lord Justice Moore-Bick said in the MSC Mediterranean Shipping Company case, and I quote, "There is a real danger that if a general principle of good faith were established, it would be invoked as often to undermine as to support the terms in which the parties have reached agreement." A fourth example is the recent recognition by the Supreme Court, overturning a unanimous decision of the Court of Appeal, 2 of whose members were shortly to become members of the Supreme Court, of the validity, subject to any question of estoppel, of no oral variation clauses. The case is MWB Business Exchange Centres against Rock Advertising. In that case, Lord Sumption observed that there were legitimate commercial reasons for such clauses, and said, rightly, that the law of contract does not normally obstruct the legitimate intentions of businessmen except for overriding reasons of public policy, and that no oral variation clauses do not frustrate or contravene any policy of the law. These cases, and many others like them, are but examples of the way in which English law is good for business. Our courts, particularly at the highest level, have developed the law based on broad considerations of policy, proportion, and justice in a manner which is alive to the needs of the business community. There are, of course, exceptions to every proposition. I abstain from any consideration of the law of illegality in the light of the decision of the Supreme Court in Hazel and Mercer, in which the reasoning of the majority is described in effect by one law lord as substituting a new mess for the previous one. But the decision that, generally speaking, an action for the restitution of property transferred under an illegal transaction, at any rate if it is not carried into effect, will not be barred by illegality, because it does not give effect to the illegal transaction but effectively undoes it, is a commercially acceptable result. But where exactly we are as to the circumstances in which a claim which is based on illegality, or which would give effect to an illegal transaction, may succeed, and the relevant factors to be considered for that purpose, and indeed the precise status of the Hazel case on that topic is unclear. You will notice that I have not yet mentioned the B word. I have no idea what is going to happen in relation to our link to the European Union. There are many complications in relation to what will be the rules as to applicable law currently established by Rome I and Rome II, and as to jurisdiction and recognition of judgments currently established by Brussels I recast. A galaxy of commentators has examined the options and potential consequences which lie beyond the scope of this lecture. It seems to me, however, that questions of applicable law and jurisdiction are capable of sensible resolution when some modicum of sense returns. But one thing we should not belittle or doubt is the continued role of the English courts and English law, together with English law practitioners, in making London the centre for the resolution of business disputes, whether in court or by arbitration. Whatever happens on Brexit, the EU member states will remain important trading partners. Counterparties based in EU countries are still likely to sue and be sued here. Many litigants come here who have no relevant European connection at all, and no need to enforce judgments in the countries of the European Union, particularly in the shipping, oil and gas, and financial fields. The pervasive use of English law and its attraction to the business community, coupled with the fantastic skills of our legal community, judges, solicitors, and barristers, mean that our courts and arbitral tribunals will continue to have plenty of work to do. The city will remain a global financial centre. People do not choose to arbitrate in London because the United Kingdom is a member of the EU. The enforcement of agreements to arbitrate and of arbitration awards governed by the New York Convention will be unaffected by Brexit. What interest there will be for English language common law commercial courts in Paris or Amsterdam remains to be seen. The beauty of English law, the quality of our judicial and court system, and the plentiful supply of highly talented lawyers, whether they be judges, arbitrators, or practicing lawyers, will not change. Whilst we should never rest on our laurels, an uncomfortable position at the best of times, we should not allow our English reserve to prevent us from declaring from the rooftops, particularly in the presence and hearing of the merchants of doom and rumour mongers, the solid virtues of our courts, our arbitrators, our law, our lawyers, and our system. It may be that in extolling the virtues of London as a centre for the resolution of business disputes, I have taken too rosy a view. But such a view is wholly appropriate for this lecture, since Jonathan was disposed to take a roseate view of life. Many in this court will know the several stories that illustrate that disposition. The classic one of them is that in a case where Jonathan came second, some of us do not use the word lost in these chambers, he was asked by another member how he had done. He is said to have replied in something like the following way: "Well, the judge, quite rightly in my view, found entirely against us, but we gave them a jolly good fight and a good biffing." "Oh, Jonathan, how exactly was that?" his interlocutor inquired. "Well, we avoided indemnity costs." It is our continuing sorrow that we now have Jonathan with us only in memory, but the memory is an enduring one and a good one. It shall not fade. Thank you.